So, bail under UAPA has always been a problematic concept, and it has been very difficult to secure bail once a person has been charged under UAPA. How do you see the present law? And do you see that courts are rather more inclined to take a more pragmatic and reasonable view instead of a watertight approach that a bail cannot be granted?
Interestingly, this UAPL law was discussed by us when we had our national conference in Bangalore recently, where this law was, where it was shown that there is hardly any, almost 2% conviction rate in the UAPA statute. Now, the problem is not the bail in UAPA. The problem is something very different. The problem is of bail when there is a delay in the trial of UAPA accused. What the three-judge bench of the Supreme Court had said in, I think, 2021 or 22, that even in UAPA or any serious offense, if the under trial has to remain incarcerated for a long period of time, then that itself is a ground for bail. Now, when you talk of being incarcerated for a long period of time, and in this case, it was about 5 years, was considered to be a long period of time as an under trial. And when there is no certainty how much more time the trial will take place, definitely, affects the fundamental right of the person accused, because as an under trial, even though in UAPA there is a presumption of guilt, which is not so in general criminal law, this presumption of guilt cannot extend or cannot stretch indefinitely. And if you feel that these are serious offenses, it's all the more necessary that the trial should be finished very, very expeditiously. Now, if you're not in a position to finish the trial expeditiously, and if you're not in a position to give any assurance to the court as to how much more time the trial will take place, then definitely the court had taken the view that this itself is a ground for granting bail, because the trial is not getting completed expeditiously. Now, what has happened recently in the Andrabi case, where the court has taken the view that this right of bail, because of the delay in the trial, is a right by itself, and accordingly, this right cannot be fettered by the presumption of guilt in the UAPA law, because this is a fundamental right. UAPA is a statutory, it's a statute. So if you have a fundamental right which gives you a higher, protection, or gives you the right to be free, or right to be not incarcerated for a long period of time as an under trial, if that right has been already acknowledged by three judges, then the Andrabi judgment very correctly says that right cannot be taken away merely because this is a very stringent law. And according to me, very rightly so, because if it's a stringent law, and if you are feeling that this person is, accused of a very serious offense, then it is the bounden duty of the state to ensure that the trial of such a serious offense culminates expeditiously, and the person who is, accused of an offense is convicted and taken into custody. Now, just imagine a case where a person remains in under trial, and because ultimately witnesses don't turn up, or for whatever reason, it doesn't lead into conviction, which is what the statistics say about UAPA law. There is only 2% conviction in UAPA law. Then just imagine the time that a person has spent inside in incarceration. How can that time can be brought back to that person? What manner can that time be given back to that person who is accused of a serious offense? And when we say accused of a serious offense, especially in the case of those JNU students, those who were denied bail by the Supreme Court on the ground that they were the masterminds of that particular protest, I don't see the court trying to bring out a distinction as if they were like somebody like Kasab. If Kasab had been kept in custody beyond the 5-year period, because everybody saw him shooting down people and killing people indiscriminately, I can appreciate that he would be a class by itself as far as grant of bail is concerned. But somebody starting a WhatsApp chat, which basically is protesting against a law of the country, And to say that he's a mastermind when the WhatsApp chat itself did not incite any violence, to say that because he started the WhatsApp chat, he is the mastermind and accordingly he does not have the right to be released on bail, is according to me, the denial of justice, of the worst kind. Because personal liberty has always been considered to be a very, very important fundamental right of every citizen of this country. And being denied that liberty on the ground that he had started a WhatsApp chat protesting against a particular law, saying that he is a mastermind in this kind of offense, and with the trial not going further at all and not proceeding at all, according to me, is travesty of justice, and rightly commented so by the Andaravi judgment. Now, since these two judgments came in quick succession, the earlier bench obviously was shown in a little poor light, which resulted in making this reference for the asking to a three-judge bench. Whereas in my view, there was no need for the reference because the earlier judgment of 2021 had clearly said that delay in the trial is something which is notwithstanding what is the accusation, is a ground by itself to be released on bail. So,
Right.
so this is a very, very important issue as far as the country is concerned, and we must all be, alive to this. And we must also realize that we are a very tolerant nation. We have always been a very tolerant nation. We should not, be oversensitive, especially to some dissent, because basically this is a dissent being considered to be a offense, a UAPA offense. And in my view, when the right to free speech was being considered by the US Supreme Court, one very interesting line which I remember was that the fact that there are some obnoxious branches should not be a ground to cut the tree itself. And this is what is happening in our country today. Whenever this kind of criminal action is initiated because of a dissent in this country.